participant room now. If I could just have a little audio check. If a few people could just say yes, if they can hear me in the chat box. Good morning, Felicity. Lovely, thank you very much. I'm going to take that as unanimous that people can hear me. So welcome to another SMember webinar. This week, lost sound. Okay, let's see if I'm back. Not sure why that happened. I'll keep an eye on it. I'm back. So this is our eighth webinar, and we're looking at GDPR today. Just to repeat what I said when the link went down. Fingers crossed it doesn't go down again. But you know, these things can sometimes be a little bit glitchy. Fingers crossed it's not today. We've got three guests today talking on the topic of GDPR. I've got Henry Herbert, who's going to be starting the session. Then we're going to be handing over to Paul Richardson and Kevin Hawler, who are joining us by video link. Henry's going to be joining us by purely by audio. And the schedule was within the invite. So for those who printed that off, to be able to follow the flow. And at the end, we'll be having a Q&A. So what I need you to do, if you have any questions, none of you have audio, so don't shout anything at the screen. What I need you to do is type it in the chat box. I'll be here moderating those and bringing those questions to our guest speakers at the end. So all that leaves me to do is to hand over to Henry. So what I'm going to attempt now is to turn on Henry's audio and welcome him fully into the room. Good morning, Henry. Can you hear me?
Morning, Andrew. I can hear you nice and clearly.
Super. I'm going to assume everyone else within the room can hear you.
Okay, brilliant. Well, look, I'll take it away. Well, first of all, good morning, everyone. My name's Henry Herbert. I'm a partner at Herbert & Ball. We're a specialist data protection consultancy specialising in GDPR. I'm a former solicitor myself at a city law firm where I gained a lot of experience in international transactions dealing with data protection issues. So I'm going to give you a brief overview, basically, of what GDPR is before we delve into the specifics of this session, which is essentially marketing and your website, which are two of the highest risk areas under GDPR. So what is the GDPR? Well, I'm sure you've all seen, you know, the various articles on LinkedIn, the pop-ups and ads and everything that's now kicking off in the run-up to 25th of May. But it's the General Data Protection Regulation, an EU regulation that's going to be implemented across all member states in the EU with effect from 25th of May this year. This replaces the existing Data Protection Directive, on which the UK's Data Protection Act is based. So the UK has implemented the directive via the Data Protection Act at the moment, and that will then be repealed, not the Data Protection Act itself, which will be repealed separately by a Data Protection Bill, which is currently going through Parliament at the moment. Now, to give a background to GDPR, the real reason this is being introduced is to update data protection law for the 21st century. Now, you'll see on the slide, the directive, that 95 for the first slash, that shows that the directive came into force in 1995. So obviously things have changed a lot since 1995. YouTube, Facebook didn't exist. The internet was a very different place back then. And computers as well have moved on substantially. So essentially what the EU is trying to do is update it for all the various technologies that have come into force in the past 20 years. So cookies, advanced in general technology, even webinars, things like that. And that's essentially the goal, is to bring a harmonized rule of law across the whole, to make sure that everyone has the same standards and individuals' data is protected. So I'll give a general overview of the obligation to the GDPR first, just to give you an idea of what's involved and what it means for businesses. The first point is that it's essentially a paperwork exercise, unfortunately. There's a huge amount of paperwork that businesses will need to put in place to meet the requirements of the GDPR and document their processing activities. So, for example, there's now a new requirement to keep records of processing. So whenever you're processing personal data, you need to have an internal register of all of the data you process. So you'd have, this would be with your company books, you keep it internally, and the ICO, the UK's regulator, could effectively ask you to see these books and audit you at any point. So that's the point about documentation. The other point to note is you've now got the requirement to enter into a specific data processing agreement with all of your data processors. So things like your website hosting provider, your email provider, and anyone else that essentially processes data on your behalf, but doesn't actually do much in terms of deciding how the data is processed, apart from basically storing it and how it's stored. So that's the obligation in terms of documentation with your third parties. You've also now got, as I'm sure you'll be aware, the requirement essentially for explicit consent wherever you're relying on consent to process personal data. So up until now, there's been a bit of a grey area with implied consent, which has been acceptable in a large number of cases, or at least even where it hasn't been acceptable, it hasn't really been enforced. So that's all being done away with, and you're essentially, if you're relying on consent, you've got to get someone to tick an unticked box. So you can't have a pre-ticked box or a message underneath a button saying, by doing this, you consent to this. That's no longer acceptable. There's a number of requirements for consent, but the main one is that it's unbundled from other obligations. So if someone wants to enter into a contract with you for a particular service, you can't make them consent to marketing as a condition of that service. It's got to be separate, truly freely given, unambiguous, and a range of other obligations, but basically a lot harder to get. And if you're trying to find a way around it, you're probably doing it wrong. The best way is to be completely honest and give people a truly free choice to tick a box to consent to whatever it is you need them to consent to. Now, you don't always need consent for everything you do, but for marketing, it will generally be required, except for a few limited circumstances, which we'll discuss later. The third bullet is the appointment of GDPR-compliant data processors. So when I was referring to the data processing agreements you'll need to enter into with your data processors, this is essentially linked to that obligation that you as a data controller for your website hosting provider, your email provider, you're responsible for ensuring that they're compliant with the GDPR. So you're actually responsible for auditing them effectively to make sure that they're processing data in accordance with the GDPR, which is quite onerous. And really, you're meant to go in and at least give them a questionnaire to answer and satisfy yourself that they've got sufficient measures in place to protect personal data. Otherwise, in the first instance, as the ICO looks at it, they look at the data controller as the person who should take the blame. Data processors can themselves be liable for various breaches, particularly in relation to storage of the data. That's a significant change. But in terms of data controllers, which most businesses will be, at least in some respect, they're primarily liable under the GDPR, and that's a continuation from existing law. Cyber and information security. So the GDPR requires all organizations to put in place appropriate technical and organizational measures to protect personal data. Now, what that is and to what extent you need to put in measures depends on the data you're processing and what sort of organization you are. Sensitive personal data, so things like health data, requires extra protection and generally will always need to be encrypted or pseudonymized, which are two new terms that the GDPR introduces. Encryption, obviously, you'll be familiar with. That's been around, but pseudonymization is a new sort of buzzword they brought in, which effectively means you give someone's name a different name, much like an author would use a pseudonym, So it's not actually possible to easily identify the data. Only you can identify it with a separate set of data that's stored separately to effectively decode the data. But it's important to be clear that encryption is not mandatory. It's highly recommended in most cases, and particularly for certain types of data. But if you can also justify it with other security measures you put in place. If you've got a very secure CRM, for example, and you've only got customer list, for example, name and email address, you might consider that actually encryption would be too difficult to implement or too expensive. And as long as you can justify that, there's various tests in the relevant article of the GDPR, then you shouldn't be in trouble at all. It's not mandatory, highly recommended, as I say, but if it is simply too costly for the organization to implement, then generally you'll be able to rely on that as long as you've done the proper assessment and genuinely considered it. So don't worry, don't panic about encrypting everything in the first instance. You do have the ability to carry out an assessment and make a decision based on the costs and various other factors and security measures you have in place. The next bullet is data protection officers. Now, again, you may have heard that this is mandatory. Well, it's not mandatory for all organizations. For most private sector businesses, the requirement will be where they're processing data on a large scale, and it involves the monitoring of individuals on a large scale. So the issue here is there's a bit of uncertainty about what large scale means. Monitoring is fairly clear from the regulation, so that would actually be things like the use of cookies. Now, if you're monitoring, this is the issue. See, a large number is very subjective, and there are some criteria in Article 29 Working Party guidance as to what a large scale means. So it can be, for example, if you're the biggest organization in your sector, even if your sector isn't very big, they might consider that that's large scale. So the guidelines aren't actually very helpful. If anything, they make it more complicated. But if you're using intrusive cookies on your website, so for example, Google remarketing, things like that, Facebook Pixel, or you're doing a large Facebook advertising campaign, I would recommend that you seriously consider appointing a DPO, at least until it becomes clear that it's not required. And there are fortunately very cost-effective solutions to do this. You don't have to employ a full-time person to do it. It can be done remotely. And we've seen options as cost-effective as £150 a month, so it doesn't need to break the bank, and you don't need to employ someone full-time for this necessarily. You may want to, of course, if you're concerned, but there are flexible options that are now being developed commercially to meet this new requirement. And one data protection officer can actually be a data protection officer for several organizations. The next point is about breach notification requirements. So you may have heard, for example, that you've got to report data breaches to the ICO, and you do, that's correct, but only certain ones depending on the risk that's posed to individuals if their data is breached, which is a broad definition of essentially anything that could harm the data. So unauthorized access by employees, as well as hacking in the traditional sense, which most people consider to be a data breach. Now, is essentially the test is whether it's more likely than not that it would cause harm to the data subject, i.e. the individual. So the reality is actually in most cases, most breaches will need to be reported because the ICO takes the view that the data that could be hacked from you could be combined with other data out there that the hacker already possesses and therefore used for various nefarious purposes, including identity fraud and things like that. So generally, most breaches will need to be reported in effect. The key point to note here is that measures like encryption and pseudonymization can actually protect you from having to report a breach. If you can show, for example, that someone accessed your CRM and it was encrypted, and the keys weren't compromised in any way, then you would consider that there was no actual access to the data itself, and there's therefore no risk harm. So that's a key point to note about encryption and pseudonymization. Equally, if you had pseudonymized the data and they couldn't identify who the people were, you may not actually have to report a breach, which you otherwise would if those measures weren't in place. So that's a key factor to think about when you're implementing the security measures to protect data, is how confident are you that you won't suffer a breach, or that the other measures you have in place are enough to stop unauthorized access. versus the cost of encryption and your confidence, your ability to report within 72 hours of becoming aware of the breach to the ICO with a range of information about the breach. So it's essentially, in a lot of cases, a commercial decision, and based on your appetite for risk, on whether you want to implement encryption and pseudonymization in general business circumstances where there's no sensitive personal data involved and the amount of data is fairly limited. The next stop is about new individual rights, and you'll have seen the title of the webinar, which is hopefully why you came along, which is the ticking time bomb. It's quite exciting, quite scary, but this is one of the points that is relevant here. So we actually think this is generally a lower risk for small and medium-sized businesses, although it is obviously feasible. But individuals, so all of us here in our capacity as individuals, have the right to ask for our data from any data controller. And at the moment, under the Data Protection Act, there's a £10 fee to exercise those rights. Now, funnily enough, as soon as the £10 fee is removed, suddenly people start caring about their rights. The £10 fee seems to stop people asking Facebook and Google about their data. So this is potentially a risk to be aware of, particularly if you have a large amount of data or you have a mailing list, that anyone on that list could in theory ask you why you've got their data and a range of other obligations, including to delete it or even transfer it to another data controller in effectively an Excel spreadsheet. So if you're a little bit worried about that happening, I'd suggest you go through all of your data and cleanse it and remove anything you're not confident you have a legal basis to process the data on. So, for example, consent or legitimate interests. Finally, there's a general requirement, and I'll hurry through this one because I think we've covered these in probably a bit too much detail, but data by design, your business has now got to become very data protection based and design and privacy friendly. So you should be thinking about privacy whenever you're doing anything, whenever you're sharing data, taking on a new supplier, or implementing any internal procedures. Privacy should now be at the forefront of your determinations. So we'll move on to the next one, which is why GDPR matters. Now, you may think that this is just another bit of EU red tape, which of course it is. But the reality is that this is one that will affect you, unlike many of the other laws, which there are often exemptions or aren't really applied in reality. And this slide will explain exactly why. So, and hence the topic about your website, you see. So the GDPR impacts the visible parts of your business. So in particular your website, but also your procedures at things like trade shows and emails you send out. And for the trained eye, and at the moment there aren't many people I think who are aware of what to look for, but as we approach the 25th of May and the media starts building up, well, potentially the scaremongering, but also the awareness of GDPR, individuals will start to think about their rights and what to expect from businesses, and they'll start to know what to look for businesses that aren't compliant. So, for example, your website obviously is public. Things like cookies and your privacy policy, which we'll come on to later, are going to be very easy to spot. And a non-compliant privacy policy is particularly easy to detect because it requires certain information to be said in a very specific way. At the moment, under current law, what you contain in a privacy policy is largely up to you, as long as you give a good general description of what you do. We haven't seen any cases of enforcement against that, but that's all now set to change. The second point is, as I alluded to earlier, is this ability now for data subjects, individuals, to exercise their rights for free. So expect to see an increase in these. I mean, Facebook and Google obviously will receive hundreds of thousands, I expect, of these in after May until the end of the year. But it is a risk that you need to be aware of. Particularly if you have any disgruntled customers, any disgruntled employees, anyone like that. Is the sort of reason people submit this isn't because they care about their data. Generally, it's because they want to cause trouble for an organisation. So you should be aware of the need to respond to that within 30 days in pretty much every case, unless you have a good reason not to, or it's too difficult. Thirdly, this is perhaps what we think is the biggest risk, which has not really been addressed, we don't think, in most mainstream publications, which is the headline fines, which are unlikely to be imposed, obviously, for a small and medium-sized business of 20 million. They do, however, obviously increase the prominence of the law across the UK and Europe as well as worldwide. And sooner or later, people will start realizing that actually, if you're not compliant, you can report someone to the ICO as an individual for non-compliance. So, for example, if a website's not compliant, I could go to the ICO and say, look, I'm concerned about submitting my data to this website because they don't have a privacy policy, or they're setting all sorts of cookies which they haven't got consent for. Now, from a competitor perspective, we hope most people wouldn't do this, of course, but the reality is there are people out there who engage in this sort of behavior, and it's quite an easy way, I think, given it will only take an email and a link to a website, to cause potentially a lot of trouble for a business, particularly if they haven't done anything to prepare for GDPR. Because although you're unlikely to get a 20 million fine, if you've done nothing whatsoever to prepare for the GDPR, you might get, say, a £10,000 fine or a £50,000 fine, which is equally crippling to most businesses, as I'm sure you'll agree. So there is a risk that competitors will report other competitors, or businesses will report their competitors to the ICO for non-compliance as soon as they start becoming aware of what they've done to comply. It's only a matter of time before they realise, well, everyone else has got to do this too, and I've spent a lot of money on compliance. Why should I have to bear this burden, and my competitor gets away scot-free? Or potentially more maliciously, how can I use GDPR to cause damage to my competitors? So I wouldn't be surprised if we see this sort of behavior, because it already happens in competition law, which is a much harder area to do it in, because it occurs in things like takeovers, where you fail to notify the Competition and Markets Authority. Competitors will report businesses to the CMA if they find that a takeover hasn't been reported, generally because they're afraid of what's going to happen as a result of the takeover for their business. But that's much harder to detect than on websites, because it's generally pursuant to an NDA at that stage, but it's normally market rumours that tip people off. But this, on the other hand, is much more public, and the incentives, given the fines now, are much greater. So that is, we think, the single greatest risk that a business should be considering, and hence why your public-facing aspects of your business are particularly important to get right in the first line of defence. And as the final point says there, all it can take is a single complaint. It doesn't have to be 100; it can be just one that sort of effectively opens the can of worms for a business that's done nothing to comply with GDPR. So we'll now touch on marketing. If we're running out of time, let me know. I can speed up.
No, it's okay. What I was going to do, just very quickly, because we've had a couple of questions in. One of them is, I think, is going to be answered very shortly. The other one I just thought I'd get in there is from Roberto. And when we talk about data, are we talking about data for employees or customers, or i.e. companies as well?
Oh, I see. Well, essentially, the definition is personal data, so it's any data that relates to an individual. So if you have, for example, an info@company.com email address, that will generally not be personal data if it belongs to a company, because it's attached to the company itself. Now, if it's a little bit tricky, because actually in certain cases, if you've got a single director of that company, and he uses that address to sign up for something, and there's no one else in the company, you could say, well, actually, that's got to be that person because he's used that address. So the problem is, it basically depends. But generally, names, there's all sorts of common types of personal data, which everyone would certainly agree is personal data. Names, email addresses, physical addresses, phone numbers, all things that can be used to identify someone, but also employee data, both internal and so your customer addresses as well on your mailing list. But also things now like IP addresses and cookies, particularly Google Analytics, things like that, which are designed to identify individual users. The EU takes the view that because you can combine that data with other data you hold or other data that someone else holds, that is considered to be identifying of an individual and therefore is personal data. So no, obviously that's the core question, and you should basically err on the side of caution if there's any doubt. So I would assume, for example, that in all cases IP addresses are personal data, because in certain circumstances you could go to a court and get a court order to get the actual identity of the person behind the IP address from the ISP, the internet service provider, and certainly that is the way that the GDPR is leaning. There was a debate for the past 10 years about dynamic IP addresses and circumstances where you've got a family logging onto a computer from a single computer in 1995, for example. But that has now become less of an argument, you see, as everyone has their own device and can be identified. So you should assume, because there will invariably be at least one person who you can identify, that it will always be personal data, and build procedures around that to deal with the various subject rights. Because if you haven't disclosed that you're processing personal data, you see, then you won't have provided them with that information in the privacy policy, and therefore you can get in trouble. So if you consider an IP address wasn't personal data, for example, but the ICO disagreed, then you wouldn't have been processing on a lawful basis. So it's basically safer to, if you're not sure whether you think something relates to an individual and could be used to identify them, you should consider it does, if that's helpful.
Super. Thank you very much, Henry.
Okay, brilliant. So look, I'll crack on with marketing and consent. So this is probably one of the biggest issues that everyone's facing at the moment. And I'll be completely honest here. What you'll often read online, for those of you that have been reading about marketing and consent, is that you should be going back and re-permissioning your data. So if you've got implied consent to send people messages under the current law, you now need to go back and get express consent. And of course, that is strictly true. If you haven't got sufficient consent to meet the new stricter GDPR requirement, then you're going to need to go back and ask them for proper consent. The issue, however, which is not really being discussed because of the issues it throws up, particularly for organizations with large email lists, is what happens if you sort of got this data and you can't identify whether you actually got consent for it, so you're not sure. Or you collected it, for example, at a trade show and it was added to a CRM at some point, but you don't know that now because it was years ago and you haven't kept records of where it's come from. Well, the answer there is you're unfortunately in a very difficult position, because you're effectively taking a risk if you go back to people who you're not sure about the data, because they could come back and say, well, hang on, can you show me when I consented to this email in the first place? And if you can't prove it to them at that point, then you can get into trouble, because basically if you can't prove it, it doesn't exist. You may have got it, someone may have given you their business card at a show, but if they then ask for it, where did my consent come from, and you can't find the business card, or you can't say it came from this business show, then it doesn't count as consent. So you essentially have to make a decision on what data you've got, segment it into data you're confident you've got consent for, or sure you've got consent for, and essentially make a commercial decision based on the risk of what you think the chances are of someone complaining are versus the value of the data. And I mean, it's a very difficult decision to make, but for some businesses that don't have the consent, they have to go back because it's the whole of their business. So they don't actually have a decision to make, really. It's sort of a life or death thing. I would suggest that you start with the safest data where you think you've got consent and go back and see if you receive any complaints, and then slowly sort of move through your data as far as you're really prepared to go, in terms of how confident you are you've got consent. And go back, but you've got to be extremely careful here. And our general position is you shouldn't do this at all. I mean, if you're not sure you've got consent, the strict position is, well, you shouldn't be going back. So that's really the starting point. But we appreciate that in reality, that's not an option for many businesses. So if you are going to do it, you've got to do it in a very careful way. And I would suggest that you break down the data into the safest and start with that. But that's a very hard decision to make, and companies have been fined for getting it wrong. Notable examples are Honda and Flybe, which they actually went to. The problem there was they went to people they knew who had opted out, as well as people they weren't sure about. So if anyone wants to have a discussion with me about that, I'd suggest you get the proper legal advice first, because it's a serious risk, and if you get it wrong, the ramifications can be disastrous. But equally, if you don't do it after 25th May, you can end up with data which you've got no consent for, and the risk now is that the fines are going up. So if you try and do it after 25th of May, the consequences can be even worse. But anyway, let me carry on with this slide. So just to explain a bit about marketing. Marketing is very broad in its definition, as you'll see here. So this is the current Data Protection Act definition under current law. And then you've also got that being transposed into the new data protection bill, which will repeal the Data Protection Act to effectively implement GDPR into the UK statute book. So that even, and another question I'm sure someone will have is whether or not this will continue after Brexit. Well, the answer is yes, it will, because they're implementing this law on the 25th of May. To coincide with the GDPR and make it national legislation for time to come, largely because if they don't do that, it'll be very difficult to transfer data in and out of the EU. But here you'll see the definition here is the communication by whatever means of advertising or marketing material which is directed to particular individuals. So essentially very broad. And then you've got the ICO's additional definition, which says it's actually a bit broader than that. And now this is where they say it promotes the aims or ideals of not-for-profit organizations. Well, they've actually said that in relation to for-profit organizations, not very helpfully. So this has been heavily criticized, but you essentially should consider most communications you send that are promoting your organization in any way to constitute marketing. Certainly the ICO would consider they were, and you'd have to be able to defend yourself, or at least your interpretation, against the ICO in a tribunal, if that ever did come down to it, and they imposed a monetary penalty. And then consent is now, this is now the new GDPR definition. I've highlighted the key terms here that have changed. So it's an unambiguous and clear affirmative action. That's what they're trying to get around, as I alluded to earlier, with the unticked tick box. So yeah, on your website, when you've got a sign-up form, what you want is an unticked tick box where someone can consent to marketing, and you've got to be very clear about what they're going to receive. And if you're offering multiple things, so for example, news and offers, you should segment those into two separate things, because it's conceivable someone could argue they wish to receive news but not offers from you, as silly as that may sound. I would recommend that you avoid that risk by breaking things down as much as you can, because consent has to be unbundled. That's another buzzword they use. So I'll just move on to the next slide. So let's talk about what this means. Now, it's a little bit complicated, the email marketing rules, and it will continue to be complicated going forward. But there's another separate set of legislation called the Privacy and Electronic Communications Regulations, which essentially governs email marketing and other forms of electronic marketing, and is due in due course to be replaced by the e-privacy regulation, which was meant to come into force at the same time as GDPR, but it's been delayed now because they haven't been able to finalize the text in time. But essentially, if you're doing email marketing, you've got a number of requirements to meet. The first one is that the email address itself was lawfully obtained and fairly processed. So really, I think what the key point here to note is that data purchased from data brokers is generally going to be unlawful. I won't go into a huge amount of detail why, but essentially, no one's got the proper requisite consent to sell data on to someone else, because you essentially have to identify them by very clear category of business that will be sold to. And after GDPR, you'll have to identify them by name as well. So, if you've got some data from a data broker, I would suggest that that's the sort of data you want to delete fairly quickly before the GDPR, because you'll have to inform everyone whose data you've got that you've got their data. And I think the litmus test is basically whether you think what someone would think if you told them you had their data, because chances are the individual would say, well, no, there's no way I consented to that. So in terms of emails, so if you've got an email address of a sole trader, an individual, or other unincorporated entity, you need express consent for marketing after the 25th of May, hence why people are re-permissioning their data. So this is obviously relevant for B2C, but also certain B2B, which is another common confusion. Some people think, well, there's B2B data and there's B2C data. It's not actually that straightforward. You've got a further distinction to make between corporate entities, so companies, LLPs, and similar legal entities, and sole traders and individuals. Sole traders are considered to be individuals for the purpose of email marketing, and would need express consent. Corporate entities, you can rely on legitimate interest. So an info@company.com address, you can rely on your legitimate interest to email them. You can also bizarrely rely on what's known as a personal corporate email address. So for example, my email address is henry.herbert@herbertball.com, and we're an LLP, so that is actually considered to be fair game to market to, in your legitimate interests. Now, it's a little bit harder than that because actually establishing the legitimate interest, is quite tricky, because you've got to do a balancing test against the privacy of the individual and your interest as a commercial organization. And you do have an interest in direct marketing, but you've got to weigh them up. So I would suggest that adding email addresses that you may have got from the public domain to a mailing list and effectively spamming them with your email marketing is not going to be considered to be legitimate. However, if you wanted to get in touch with a personal email with a genuine inquiry about, for example, working together, that would obviously be considered legitimate interests. There's also the soft opt-in, which is a slightly complicated and esoteric exemption for where essentially if someone signs up on your website, for example, at a checkout, you can give them the chance to opt out of marketing communications at that stage. They're considered to be in negotiations for sale, but it's very hard to implement. And actually, come 25th May, people are going to be expecting to see ticked boxes, as I mentioned earlier. So I wouldn't actually recommend you rely on this, partly because it's so limited to what you can actually advertise to them, which is similar goods and services to what they purchase from you, which is a hard determination to make, actually, in many cases. The second half is phone, which is a slightly different regime. So phone numbers, basically, if you've obtained them again lawfully, so for example from a business's website, you can phone them with marketing calls as long as you screen them against these preference service registers. So TPS is the telephone preference service, so that's for individuals, and CTPS is the corporate telephone preference service for companies or LLPs, anyone else who's a corporate entity. So you have to first screen them in order to market them. They also have to have not previously told you they don't want to receive calls from you. So, but in most cases that shouldn't be the case. You already know that, but you do need to keep a record of who's objected to calls from you in the future, so you don't make the mistake. And then also about lawful processing, you will need to provide people with a copy of your privacy policy or privacy notice in order to make that processing lawful. That's a key requirement to note there, because it's quite tricky to implement, and you've got to provide quite a lot of detail, and you've got to make sure you provide it in every case. So we suggest that attaching it to an email as a PDF would be a surefire way to make it safe when you first collect someone's data. So for example, after a business show, you would send an email with your privacy notice if you haven't provided it at the business show itself. And that's just a bit of procedural work which you need to build into your processes for collecting data. We expect in due course what will happen is people will include a privacy policy link in their email footer. So with all the confidential message information you tend to see, and that will generally be considered to be enough. But we haven't had confirmation of that. So at the moment, we suggest to be completely safe, you actually send them a PDF copy until that becomes clearer. And then legitimate interest or consent. So you can of course rely on legitimate interest for certain phone marketing as long as you screened it. It's not the same as email. However, when you're getting information from someone on a website, you need to make it clear what methods of communication you're going to send to them, and give them the chance to opt out. So if you're providing a phone number for the purpose of checking out, you can't then phone someone with marketing unless you've told them you're going to use it for that purpose. That's considered unfair because they didn't know when they provided it that it would be used for that purpose. And if you provide multiple methods of marketing, you should allow people to choose which ones or which channels they'd like to use.
Henry?
So I'll hand over now to Kevin and Paul, and they'll talk a little bit about how GDPR affects your website.
Henry, can you hear me?
Yes, I can.
Can I just ask a couple of questions before we quickly hand over? There's been a few. There's been 2 or 3 questions with regards to gaining consent on an actual phone call. So I think there's been 2 or 3, maybe 4 questions. I think they're probably the most simply put. Can you gain consent over the phone, and what and how do you collect, and how do you collect proof of this?
Very, very much, and that's actually one of the ways we recommend to help deal with this issue of if you're not sure if you've got consent. So if you can get someone's phone number, for example, from their website, this is the thing, you've got to get the number firstly lawfully in the first place. If you've got the number for one purpose, for example, a checkout order, it's generally not considered okay to then use that to call them to get consent, because they didn't provide the number for the purpose of marketing, as I was alluding to earlier. But assuming you can get the number lawfully and you've screened it properly against TPS and CTPS, and they haven't indicated that they don't want to receive calls from you, you can absolutely ask them on the phone that whether they'd like to receive marketing communication from you and how. And that's just a conversation you'd have with them. You should have a rubric, obviously, of what you want to ask and what you want them to consent to. And I would suggest that here, obviously, you'll have the conversation, assuming they say yes, and to what you note that all down, and then you send them an email, assuming they want to receive email marketing, hence why you're calling them, because you could call them anyway for marketing. You then follow that up with an email, say, look, thank you for confirming. We look forward to sending you communications in due course. Now, technically, what would be safer is to actually then get them to confirm that in email. Could you just confirm you're happy, based on the basis of our conversation, that you're happy to receive emails from us in the future, and that would count as valid, provable consent to record on the CRM. But I'd suggest that, to be honest, the chances of someone consenting to your emails by phone, you'll have a record of the phone conversation. The fact that you send an email noting what they've agreed to, if they don't say anything at that point, I think it'd be very difficult for them to challenge that. But to be technically safe, absolutely, you need to get them to confirm by email that they're happy with what you've just said on the phone, after they've said they're happy for you to email them. If that helps.
Okay. Yeah, thank you very much. There are other questions, but I'm gathering them, so don't worry, everybody. We'll get through to them. I'm just aware that, Henry, you've been talking for 45 minutes, and you could probably do with a glass of water or something.
I could actually. That'd be great.
No. So I think, like I say, I'm not missing out any questions, everybody. What we're doing at this stage, we're moving on and passing over to someone else. So thank you very much for the time being, Henry. You can just all bear with me whilst I turn various permissions off in terms of audio. I'm welcoming Paul Richardson to the room now. Paul, can you hear us?
I can indeed. Am I coming through? Can everybody hear me?
Yes, I can personally.
Right, thanks very much. As you can tell, there was an awful lot of information in Henry's presentation there, and this is something that Kevin and I both work for what's called an inbound marketing agency. So digital marketing, we've worked in the web and digital sphere for a long time. And we've been watching the arrival of GDPR with interest, because it has a direct effect on the kind of things we can do for clients, and how it's going to affect people who have got existing websites out there in the market at the moment. There's an awful lot of this that is going to have a serious impact on how people market. The industry that most of us that are on this webinar belong to thrive and work around the use of data. Databases are used to market shows, they're used to market to exhibitors, they're used to harvest leads. There is an inherent behavior in the industry that data is shared to some degree to allow people to process further down the line. And as Henry alluded to, there's no right to collect data and then hand that over to a third party, because the third party doesn't have the consent of the individual concerned. So there's some very tricky areas there, some of which may be a little grey that we'll tease out over time. However, it's not the kind of stuff that you want to be gambling with at this point as members. In terms of how this is going to affect your website, I'd like to introduce Kevin now. Kevin's our hands-on project director at Vivid Fish, and he's been neck deep in working on this kind of stuff for clients. So I'll let Kevin talk me through the effects of GDPR and your website and what must and mustn't be on there. And then once Kevin's been through that, I'll pick up about how GDPR might affect your marketing and what you can do in terms of marketing activity and tactics that might enable you to go through this relationship without any hiccups or problems. So, Andrew, could I ask you to mute me, which will no doubt give you great joy, and bring Kevin into the fray?
Hello, you all hear me?
Hello, Kevin. Yes, I can hear you.
Fantastic. Okay, as Paul said, I work on the more practical side of the inbound marketing and web development part of what we do. And I'm just going to run through a few of the more practical things you need to be aware of and things you will have to look at and take into consideration and probably make changes to on your website. The vast majority of websites running for businesses today are based on some kind of content management system. To enable these to run properly, they will use cookies, and they will use multiple cookies. Along with that, the vast majority of us use some kind of tracking software such as Google Analytics, Facebook or LinkedIn tracking for advertising, maybe lead forensics. And all of this software that we use also needs explicit permission from the visitors of our websites to actually be tracked and actually use their data to monitor what they're doing on our sites. So the first thing is you need to know exactly what system you're using, what cookies it's placing, how many it places, what they're used for, and you need to know what tracking software you're using and what cookies that places and exactly what that's being used for. Once you have that information, you need then to allow users an option of opting out of using cookies that aren't essential and are invasive or tracking cookies, and actually opting out of anything that collects their data. You can't do this in a single, one opt-in or one opt-out does kind of covers everything. You have to list the invasive or tracking cookies that you're using and ask people to opt in or opt out on an individual basis. So if you're using Google Analytics, LinkedIn tracking, lead forensics, SharpSpring Analytics, you are then asking people to opt in to use for specific cookies rather than just a global, we're tracking you. So it's quite important you have a good understanding of what you're using, how you're using it. Then following on from that, if you're asking people for their data on contact forms or on forms to enable them to download resources from your website, you have to be very clear what you're going to do with the data they share with you. And you can only use that data you collect for that express. I've forgotten the word. So you can only use the data you collect for that express item in the opt-in. So if you collected something to download an ebook, then and the ebooks regarding GDPR, for instance, is one of the ones we're doing. You can't then use that data to send them marketing materials about other services you offer. It is really based on what they opted in for and what you've said at that time. Use the data for. It should be fairly easy to implement across most website systems. It will more than likely need the input of your web developer or a web developer to get this working for you. But it shouldn't take too long in terms of technical time to make it happen. The last thing that you really need to be aware of on your website is you really have to display all your company contact details, so company name, address, telephone number, email address, limited company number if you're a limited company, and their website privacy policy, cookies policy, and terms of use should be easily accessible and clearly displayed and linked to, so people can access them very simply without having to go looking all over them. And in terms of the main practical things, that kind of covers it. Paul will explain a little more regarding how inbound marketing, digital marketing could potentially help you along the lines of complying with GDPR and making sure the leads you generate online are compliant with GDPR. If Andrew could switch him back on.
Hi, thank you, Andrew. Hopefully I should be audible to everybody. One of the things that we've wrestled with as a digital agency over time since the GDPR certainly started to come to light that it was actually going to be something that would impact on everything we do and everything our clients do, was looking about how we collect this data and how do you encourage people to actually participate in your marketing. As Henry alluded to at the beginning, it's all about permission. This is all about permission-based marketing. It's all about getting people to consent to you to engage with them. We've run some exercises with clients where we've done some database cleanups, doing pretty much what Henry was talking to as well, which is saying, going back to those people who you've got previous data and saying, hi, we're a responsible organization. We have you on our database records. This is what we have you down. Do you still want to receive this? Some of that can be quite challenging for clients. We have had databases reduced from 45,000 data a set down to just over 4,000. Which is quite a shocking reduction, but one of the things to bear in mind is if you go through that exercise, and there's a closing window to be able to do that until the enforcement of GDPR, is that you've just then created a database of 4,000 people who have actually indicated that they want to talk to you. So you then have a warm database. It's not the vast database you had before, but at least they're potential clients. Part of the problem with that is that that involves some part of push marketing. And push marketing, email marketing, telemarketing will be significantly reduced. There will be an impact on it because of the having to get the consent. And what that's done, it's affected a shift in the dynamic of marketing, because it's something that was happening over time before the advent of the internet, with websites with lots of content available, and content marketing was a big driver for this. Pushing material out there for people to find, engage with, collect, download, read, has put the information that used to be the prime weapon of your sales department, who could go out and say, I can tell you about the latest, greatest development or update, that's now sitting in the hands of the buyer, because the buyer is starting their buyer journey with a web search. And some stats that were published last year by an American research company across B2B and B2C said that 89% of all buyer journeys begin with an internet search browser. So before people are engaging with anything, their first point of engagement is with a web search, and that will take them to your website. And if your website is created in the way that you have offers, and we talked about gated content, and you sign up on a gated content, you specifically state what you want, what you're going to do with that, and what that information's for, how long that data will be kept, and people then say, yes, I want to engage with this, download the content you may have put there. That person's put themselves as a qualified GDPR lead. They've actually said, yes, I want to be communicated with and marketed to. And that's point 3 on the slide. That is termed inbound marketing. It's actually bringing people to you for them to engage, for them to be a sales lead. At that point, when they've done that, they have given you that consent, that permission. You can then follow that lead up. You've actually got a qualified lead that's giving you the information. They should be, by dint of the fact they have searched for that information, they will be further down their buyer journey, so closer to a closure of a sale than they would be if you hit them on a cold call. So this is picking people up when they are ready to buy. So that then takes the next point. They've already given you the permission. They're ready to go. And it will make them a compliant lead. So they are coming to you at the point when they are they're ready. So what does that start to do? That starts to make this a wonderful spam-free world. And the great joy of that is our inboxes and our spam filters won't be groaning under the weight of massive emails where people are hitting us up for any number of things, data passed on. What that does then mean is that once you have permission from that person to market to them, they will receive and start to receive the right emails at the right time. So if you're bringing people in on a pre-qualified approach through inbound, those people then starting down a buyer's journey, you can then communicate with those people because they've given you permission to help. So anything that you're sending to them afterwards will be helping them move towards making a buying decision. And because you have the permission, that allows you to continue that communication. It also then means you will know where that person is on their buyer journey. So you'll then be able to say, right, this person's at this stage. if I can provide them with this bit of information and this help, it helps move them on. And from a marketing point of view, the advantage there is it's a reduced cost. You're reducing your cost of your marketing because you're only approaching people who've said, yes, I want to talk to you. Yes, I'm interested in the product at this moment, so I'm moving towards a buying decision. And yes, the information you're providing me can help move me along. So the GDPR is actually helping people sharpen up their marketing to make their marketing more applicable to the people they're targeting. And hopefully, with the right kind of inbound strategy and mechanisms we've been talking about, it will reduce the risk of anybody going to the ICO and saying, I didn't opt in, I haven't done this. Because using the right software and packages behind, you will be able to demonstrate that your database lead will be an opt-in database. So you can actually say, Andrew Harrison did contact me, he did check these boxes, we have sent in this information, he is an engaged person, and you can actually demonstrate that he was an engaged sales lead. That kind of wraps up that. We're happy to discuss this in more detail, happy to answer questions at the end. I'm going to hand back to Henry now, who will wrap up with one of his terrifying slides again. Andrew, over to Henry.
Hi there, Andrew. Can you hear me? Andrew? Hello? Hi, Andrew. Can you hear me?
Are we back?
Andrew?
Hello?
Hi, Andrew. Can you hear me
I think
okay?
we're back. Yeah, I think we're back.
Sorry, I think something happened with the handover. Never mind.
Not a problem. It was a momentary glitch. I think we're back.
Brilliant. Okay, so this final slide has been alluded to by Paul as a slightly terrifying one. The website privacy policy. Perhaps not the thing that you've heard about in terms of GDPR as the main change, but actually I think the most important change, particularly for a small and medium-sized business who doesn't have a huge amount of money to spend on GDPR compliance. As you'll be aware, there's a huge number of changes that I alluded to earlier that are required beyond the scope of this presentation in other parts of your business, including various documentation. But from the public-facing perspective, your website privacy policy is effectively your announcement to the world of how GDPR compliant you are and how seriously you've taken GDPR compliance. If you haven't put in place a website privacy policy, for instance, the chances are you haven't done anything else to comply with the GDPR. So this has got to be, at this stage, with about 3 months to go, one of your main priorities to get in place and ensure is ready before the 25th of May. So just to outline when this applies, this is going to be mandatory for every single website. Essentially, there are potential exemptions for personal use, although it's very difficult to argue that, given that websites are public and therefore anyone can access them effectively. All websites process personal data. Now, that's basically in the form of the web server, which processes the IP address. Now, as alluded to earlier, it's possible to argue that potentially IP addresses aren't personal data, but the EU doesn't really take that view, and the trend is very much against that, to argue that IP addresses are basically always personal data, because you could effectively find out who someone was in conjunction with what the internet service provider holds about the individual. So I would consider that, even if you've got a brochure website, and you haven't got any method of someone contacting you on there, which is unlikely anyway, that you'll be processing personal data. But of course, what is much more likely is that you'll have a phone number, you'll have an email address, you'll have a contact form, all of which will be processing personal data. So you'll all need a privacy policy explaining what happens to that data, where it goes, and the legal base which you rely on to process it. And you need to make sure that privacy policy is very clear and very available on the website at the point when someone submits their data. And you'll usually provide a small snippet of the privacy policy, for example, on the contact form, explaining what's going to happen with the personal data when it's submitted, so that it'll be used, for example, to respond to their inquiry or to respond to their message. And then the full privacy policy would set out more detail about the retention period and various other things, the legal basis in full detail. So as I mentioned, it's highly regulated now under the GDPR. Under current law, the privacy policy is effectively whatever you want to write. I mean, that's probably a bit too loose, because technically I think you could get in trouble under current law. It just hasn't been enforced against, because there's been nothing saying specifically what it needs to include. So it's quite difficult to enforce when you've got sort of general requirements like fairness and transparency versus the GDPR, which Articles 12 to 14 specify exactly what needs to be contained and how it has to be said. As I mentioned earlier, this is the easiest and fastest way to see whether a business is compliant or not. For example, the legal basis must be specified underneath each purpose for which you use the data, and failure to do so will mean you're not processing data fairly or lawfully, because you haven't informed the data subject how their data is being processed and what legal basis. That's one of the rights they have, is to know what legal basis their data is being processed on. You've also got to set out the new data subject rights, the whole host of data subject rights. So, for example, the right to erasure, having their data deleted, the right to access their data, the right to have their data transferred. So data portability, for instance, is a new right under the GDPR that hasn't existed previously. If a privacy policy didn't refer to the right to portability, that would be a breach of the legislation and could be reported, at least in principle. How the ICO would respond to that is difficult to say, but I would suggest that an individual who's looking to exercise their rights is not going to be happy if they come to your privacy policy and see that you haven't told them what their rights are. Now, fourthly, as I've sort of been alluding to as well, this is the first line of defense for GDPR. Your website is your first line of defense. It's your face to the world, and the quality of your privacy policy, it essentially indicates how seriously you're taking GDPR and how well you've done it. So it's essential to get this right. As you see, having none at all is obviously the worst case, but having a non-compliant one is equally bad, because you're either compliant or you're not compliant. There's no sort of halfway house. So a non-compliant one could get you in just as much trouble as no privacy policy at all. You might get in a bit less trouble, but I wouldn't want to rely on that if the ICO was investigating me. So, and you should note that actually not having a compliant privacy policy, because the transparency obligation, the need to provide this information as a fundamental right, is actually itself one of the most serious breaches under the GDPR. So, at least in principle, liable for the highest fines. I doubt I'd see someone getting a 20 million fine for not having a privacy policy. But as I say, you might get a £5,000 fine or a £10,000 fine. It's not something worth exposing yourself to the risk of, and the related issues with collecting data unlawfully and sharing it, and then exposing the rest of your non-compliance in the event of an investigation of your privacy policy. And finally, the risk that we consider to be the greatest, again, as mentioned earlier, is the fact that competitors can report your privacy policy directly to the ICO. They're meant to get in touch with you directly in the first case to raise the issue, but it seems to me that it should be fairly easy to argue that I shouldn't have to submit my data to a website owner which is non-compliant to find out why their privacy policy isn't compliant. I would expect to be able to go to the ICO and say, well, look, I don't really want to submit data to them because they don't really seem to treat it properly. So I don't want to risk it. And why would the ICO need to investigate my specific circumstances when I'm just one website user out of potentially thousands that could access the site? So actually, my identity is not relevant. And I think the ICO would take the same view there. And that's really the end of it, I think. Unless you have anything to add, Andrew, I think we're ready for questions.
I've got some questions. I mean, we're overrunning, but I hope people aren't too worried about hanging around here for a little bit longer. Most of the questions are actually directed at you, Henry. Mm-hmm. I think for a lot of people, especially myself, this is probably the first time I've actually been able to hear and speak to a group of people who I would say are qualified on this topic. You know, I think that's why there's lots of good questions coming in. I'll start with some of the earlier ones, and I think there's some really quick yes and no's to these. So, will Brexit affect GDPR?
So no is the short answer. That's a very quick one. I mean, I can explain why, but essentially the UK is implementing it into UK law directly with this data protection bill I mentioned earlier. So it's here to stay for the foreseeable future. And the reason why I can't see it ever going away is because in order to transfer data between the EU and Britain, the UK, you need to have an adequacy finding by the EU Commission. So we've got to have standards equivalent to the EU in order for them to be able to transfer data to us without any extra burdens of sort of contractual clauses and various other measures that are necessary if you're not a safe country. So it's here to stay, I think, is the answer to that.
Okay, lovely, thank you. I've got some more questions here, but I'll quickly take one from the screen. Are there people out there who you can pay to write privacy policies for you to make sure they're compliant?
Well, absolutely, a very good question. I'd say probably the best one because we do that all the time. There's a lot of people out there. I mean, you've got solicitors at the top end. You might pay anything from sort of 2,000. 1 to 2,000 for that generally, so quite expensive. I wouldn't necessarily recommend that you fork out that much for it. I think it can be done yourself, and actually you have the best knowledge of your business. We are a data protection consultancy, so we're not a firm of solicitors, but we would charge generally sort of £500 to do one of these for a standard e-commerce or brochure site. We also offer templates though for £150 for people to do it themselves with extensive guidance notes to help. So it's really up to you and how far you want to take on the responsibility and the cost. But there's certainly people out there and resources to help.
Okay, thank you. Question here from John Robson, Treasurer and Board Member of ESSA. Good morning to you, sir. Bearing in mind that everyone and their dog is likely to be reporting companies to the ICO, how likely is it that the ICO will have the time or inclination to follow through on companies?
Very good question. And the ICO is obviously at the moment, I don't know if anyone's tried to contact their helpline, but you'll be on the line for about an hour or two before you get through these days. So very busy. It's a difficult question to say. I mean, you'd expect them to go after the big fish first, Facebook, etc., as has been happening recently. But the issue is that they do have to deal with complaints. Now, they may decide not to take action for whatever reason, but they have to explain why they haven't taken action or why they haven't considered it to be an issue. And something as clear cut, for example, as a privacy policy, for them to say, there's no privacy policy on the website, that they're not taking action would be pretty surprising. I would suggest that it depends on the nature of what you've done. But this sort of stuff, whether it's within a month of the complaint or 2 months, at some point it will work its way through the ICO and be dealt with. So there might be a time delay, but I think at some point it will have to be addressed. So I think the fact is it will be dealt with. It's just a matter of time. But unfortunately, I don't have a crystal ball about enforcement. That's very much a grey issue. We do know that they've been taking a lot of police staff. Now it's not clear who they've been hiring, whether that's detectives or whoever it is. But certainly we have seen a ramping up of enforcement actions in the run-up to GDPR already. So it suggests to me that this will be taken seriously, and it's not like the cookie law. 5 years ago now or so, when it was basically ignored. This is all very clear. A privacy policy has now got to be written in a certain way. It's no longer a sort of vague document that doesn't really matter if you have one or not. I would suggest, this is why we start with the privacy policy, because it's inexpensive and it covers a risk. To the extent you want to go beyond that internally, that's really a budget issue, I think, more than anything else. But this is not the risk that I would leave yourself exposed to, due to the high chance that it will get you in some sort of trouble at some point.
Okay. I think we've probably got time, because I'm aware, at some point we have got to end the session. I think it's one of those topics where we could probably sit here for another hour and field questions. What I will say, if I don't get round to answering all of these, Kevin, Paul, and Henry, would you be happy if I put together a question sheet of those that have been submitted and we don't get to answer today, and put some content together there which we can send out to attendees to answer those questions? Are you happy to do that?
Absolutely.
Okay, no problem. Like I say, we've got time for a few more, as long as you guys have. I think people will drop out of the room as and when they need to move on. So let me crack on with another question. Can you have a combined privacy and cookie policy, or do they need to be separate? Henry, are you okay with that one, or do I need to open that up to someone else?
Unless Paul wants to deal with that. I mean, I think he already knows the answer. We've discussed this previously. I mean, there's no strict requirements to separate them. However, at least not technically, but because they have to be clear and concise, now that's now a requirement. I would highly recommend that you separate them for ease of access, because often, the cookies policy will affect all website users, whereas the privacy policy often deals with what happens when you submit data to the site, so via email, etc. So it's quite common, I think, best practice. In fact, the ICO has recommended this. It's not strict legal requirement, but they've already recommended that you separate the cookies from the privacy policy.
Mm-hmm. And where currently do we stand? This is a question from David. How do you stand regarding data held by third-party email service providers like MailChimp?
MailChimp's a great one to use. If I expect he's using it. MailChimp has self-certified itself as compliant with the EU-US Privacy Shield, so they actually store the data in the US, and that's lawful. So you're absolutely allowed to transfer data to a third party, not for marketing purposes, in the sense that MailChimp's not marketing to them. You're using MailChimp as a data processor to store your data. So, but what you do need to do is inform the person in the privacy policy that when they sign up for your newsletter, for example, their data will be stored on MailChimp servers in the US, and MailChimp is self-certified with the EU-US Privacy Shield, which is an international transfer mechanism, which I sort of touched on earlier about some countries not being up to EU standards. So you can use those providers, but you've got to make sure that they're GDPR compliant yourself. So you've got to do the audit. Now, MailChimp's committed to GDPR compliance, but there's several other alternative providers out there that obviously haven't. So that's part of the due diligence you've got to do, because as a data controller, you would be liable for them not being compliant. Okay, lovely. A couple more, if that's all right with you guys. Is that okay? Here's a question. Does the same phone consent rules apply to calling corporates? The consent point, well, it's the same rules apply in terms of the screening. So you have to make sure you get the phone number lawfully. So, from the website, for example, of the person, and then you would screen it against the CTPS. So there's two separate registers. There's one for individuals, the TPS, and there's the corporate telephone preference service for CTPS. So it is the same process. You just screen it against different registers. Okay, lovely. And a question from earlier on in the day, or in the webinar. If you feel you can't go back, and I think this is meaning in terms of going to get consent, is it safer to just delete your data? Absolutely, that is by far the safest option. And I mean, some of you may have heard about Wetherspoons deleting their entire database because they just thought, look, there's no way we can go back and get the consent. And we always recommend that as the first option. That's the strict position, and you won't be taking any risk by doing that. The problem often comes though, is there's some organizations that rely on their lists for their existence. So it's simply not an option to delete all the data, in which case there are ways to work around it. For example, using phone numbers where you can again get them lawfully and get the consent over the phone. That's a very laborious exercise. But certainly the safest option is to segregate the data, work out what you've got clear consent for, you've got implied consent for, and you need to go back to get express consent, and then anything else where you're unsure and delete it. And of course, this is a great opportunity to work out what's responsive data and what isn't responsive data. The chances are everyone's now got data they've got from years past, or data that they've had on the list but they've never got rid of, which they never clicked a link in the email, they never did anything with it, with what they received. This is a good chance, as was alluded to by Paul earlier, of reducing this list and getting it very, very tightly, defined to those you've got consent for, and will be extremely responsive going forward.
Yeah. Okay. And there's a good industry question here, and it's one I've heard before. As an official supplier to exhibition organisers, you're already aware, Henry, that this is a room full of industry suppliers. As an official supplier to organisers, we are provided lists by these companies in order to contact the exhibitors, so all of our members' clients, to provide or sell services. What steps, if any, can we, my screen's just gone out, if any, can we take to ensure that we are emailing them with legitimate interests, or within the rules of legitimate interest?
Yeah. So the data's come from who, sorry, originally, before the supplier? Who's given it to the supplier?
It will come from the exhibition organizer.
Okay, fine. So they will
Yeah, sorry, go on.
They will. It's a very difficult issue because it's not just you. It's your relationship with the event itself. And often, if you're collecting data at an event, or they otherwise supply you the data from the event after the event, you've effectively got a joint controller arrangement. So you actually need to have an agreement with. It doesn't technically have to be in writing, but obviously in reality you have to do that to prove it. So in effect it has to be in writing, but you would then set out the respective obligations of the parties in terms of the data and what it will be used for in the the exhibition company's privacy policy, which must be supplied at the time when they collect the data, and that would then set out who they share the data with and for what purposes. Now, if you're then marketing to the data, you would have to get the exhibition company would have to get consent, and the proper consent, so named companies, to market to that data. So if the supplier wants to market to the data, the exhibition company would have had to get the proper consent. Otherwise, it's not going to be valid under GDPR. So that means that they would have had to get someone to tick a box saying that I would like to receive offers from this supplier. Now, that would be, for example, when they sign up at the event. Obviously, at the event itself, on the ground, by a stand, you can then use your own procedures to collect the data and get the consent, because they then consented to you directly at the stand. It's a little bit complicated how you get consent at the stand in terms of how far you need to go. You can be super safe and record it in writing, or you can just collect the business cards and beep them in, but you have to be able to prove that you got the consent at the stand. So there's two points there. If you're relying on getting it from the exhibition company directly, they would have had to have a box to tick by consent to this being given to the supplier for their marketing purposes. If you get it from the stand, basically it's up to you to collect the data properly and make sure you've got the consent directly, if that helps.
Okay, thank you very much. I think one more, and otherwise, like I say, I think we could end up going all morning. Well, it's already near the end of the morning. One more question. Is customer data automatically compliant, i.e. they have purchased from us, so we are okay to email them or contact them with marketing offers? Or should we email the customers and ask them to opt into our newsletters?
Yeah, so the answer to that is a definite no. It doesn't become compliant because you collect it in the course of a sale. This is the point about consent being separate from anything else that's going on. Consent to marketing in particular is the real area where this comes into play. So if someone's purchased something on your site, say at checkout, you would have to have a separate tick box saying I consent to receiving, and then the various things you want to send them should ideally be broken down into things like news, offers, etc., etc. So it will not automatically be, usable for marketing. No, certainly not. But the other point is to mention the soft opt-in, which I alluded to earlier, which is a very limited exemption, which you can rely on legitimate interest for, is when you provide someone the opportunity to opt out from marketing communications from you in relation to similar goods or services that you purchase from them, that they've purchased from you. So it's a lot more limited in terms of what you can market to them. It has to be similar goods and services and only from you. That's not so much of an issue usually, but it's important to understand if you are doing that one, get the proper advice on how that has to be worded, because it's very tricky to do right. And we would generally recommend going with consent because that's what people are going to expect to be seeing on a website.
Super, thank you. I think what I've said I promised we'll do. We get a recording of all of this, so the recording will be made public in usually about a month's time. Once it's all been processed and gone through our marketing channels, we'll extract all the questions which have come through, and not just those that have been that have been answered. We'll include them all, and I'll get the guys to provide a brief summary answer to each one of those, which we'll send out to all people who signed up for today. Just to add to this, Henry's going to be talking at our AGM on the 26th of April. God, I hope I've got that right, which is being held at the Magic Circle head offices in London. Invites for that are already going out, and we've already got a good number of registrations. Good one, Luke Facey. Will I be asking permission to send you stuff? No, I won't, because I'm going to do it before the 25th of May. But very good, Luke. So we're going to be covering GDPR. We're going to be covering Brexit at our AGM. So thank you guys very much. Isn't it really refreshing to hear expert information, qualified information? This has been a first really for me in terms of some of the information I've been getting, and it's so nice to get it firsthand. Any further topics and suggestions? These webinars, we run them based upon what our members ask for. It's easier to get a room. We had 46 people in the room today. It's much easier to do this and pull in 4 people from geographically all around the country to provide a presentation than it is to set up a forum, I don't know, in a room at the Rico Arena or at the NEC. It's much easier for us to do it like this. So any topics that you'd like covering in the future, send them through to me. My email address is andrew@essa.uk.com, and we'll go out there, we'll find the experts, and we'll get the sessions set up and send out the invites. So we've also got extensive GDPR resources and papers, and we've even got, you can even get a CPD qualification in GDPR if you access the member area on the ESSA website. So for the last 2 years, we have been building it up as we've got the information from the ICO. This webinar plus the GDPR piece, they're kind of our 2 final acts, if you like, for GDPR. I think from that point on, we won't be able to add too much to what we've already done. But thank you very much for all taking part and coming along. It's a really important issue, and I'm glad we got the response from the membership that we were looking for in terms of participation levels. So yeah, I'm signing off. Thank you to Paul, thank you Kevin, and thank you Henry, and we'll see you all again at the next ESSA webinar. Thank you, bye.
Thanks, Andrew.